it stops, no one knows. We're going head into the unknown. Na, 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 na.
Hello, 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 everybody. Happy Tuesday. Welcome back to Criminality, or if this is your first time here, welcome to Criminality. So, we're back in Delphi again. I didn't expect to be back here so soon after Friday, but here we are. But before we get started, I want to talk to you guys a little bit about just a couple other cases and the fact that Casey Anthony has a TikTok. So I'm sure that you guys are all aware of that, but I just wanted to update you guys in case you aren't aware. Casey Anthony has now claimed that she is going to be a legal advocate and she is going to advocate for her daughter. Anybody who knows me knows I can't stand that bitch. So, yeah, she has a TikTok. Dun, dun, dun. So I think that she's only going to be using the TikTok platform to garner followers for herself on a different platform. But she said that she essentially is going to, at one point, she will probably address the things that her parents have said, but she believes that it's time, because she's a household name, that it's time for her to become a legal advocate, and she can't do that justice if she doesn't begin by advocating for herself and her daughter. Ridiculous. Absolutely ridiculous. So that's number one on my checklist of shit that's gone on since I had been on YouTube. Yeah, it's sickening. She's such it's like, so what? She doesn't have she's like, I've been essentially doing this, like, you know, my whole adult life. I've been a legal advocate. Does she actually have fans? Yes. Yes, Fiend, she does. She has people. So she had a handful of people that believed her back in the day, like when the case happened in 2008. She had like a handful of people. And then she did the interview, what was it, like 4 years ago, where she goes like into detail about like her, like all the things with her dad, and it's just gross. She's so fucking gross to me. So then she got more people who believed her. And I was like, I mean, people were like messaging me like, you've got to like second guess yourself now, because if anybody knows, like I said, I can't stand this girl. I absolutely believe that she is guilty of killing her daughter and got away with murder. 100%. Like, you will not be able to change my mind. No, I mean, she might as well have done an O.J. Simpson interview of like, if I had done it, then this is what I would have done, because she's so guilty. She's so guilty. But so she says like, I'm gonna address some of the things that my parents say, and like to try to garner more people to come to her side. It's the weirdest shit. Like, people were messaging me like, oh, you got to rethink your thoughts about her, and once you see this interview that she did, she's like amazing. What's up, babe?
The cup. Like that.
What?
And the ice cream.
Not until after dinner, babe. What?
Mine yesterday.
You had it after dinner. You'll survive, I promise. Apparently, he doesn't think he will. He needs ice cream. We're having tacos. It's Tuesday.
Is the meat that I like?
Yes, it's the meat you like. Sorry, I got a mom for a hot minute.
It's almost summer.
It is not almost summer. Remember, we have to have spring first.
It is already spring.
We have to have spring, and then we get to have summer.
It's already spring, though.
No, we haven't sprung forward yet. He needs ice cream before dinner. It's relatable. It really is. It really is. Oh, goodness. Yeah, he tried that yesterday too. It didn't work out too well. He got it after dinner. So this is the problem when there's ice cream around. But we also have Girl Scout cookies, so they think like they can have like 2 desserts, one before dinner and one after. Anyway, okay, so yeah, Casey Anthony, not second guessing shit. R&M, no, I'm not gonna let him have the ice cream. If that's just mean, I'm not gonna tell him that. He's 8. No, I bought these ice cream cups that are vanilla ice cream, but they have like they're almost like a sundae type of thing, like the little jars. So it's vanilla ice cream. Some have strawberry in it, some have chocolate. Everybody wants ice cream now. Give him the ice cream now. I can't do it. He has to go to football practice. Can't just go around having ice cream. He's been home for a little over an hour. The kid has already had 2 meals since he's been home. Okay, you guys are just ganging up on me now. This isn't fair. It's not fair. All right, no more ice cream talk. Anyway, okay, so that's my update with the Casey Anthony stuff. I was like going to do a video on it, and I'm like, fuck her. I'm not giving her any more time. I'm just going to mention it, and that's all she gets. The other one is Gene Hackman. So they still, and I talked about this on Friday, they still have no idea what happened to this couple and this dog. It's the craziest shit. So there are people out there that are arguing with, and I think Sleuthy said it on Friday, that there's why wouldn't the pacemaker alert that it was no longer active? And so people are going back and forth. I did a little bit of research. My dad had a pacemaker before he passed away, just, side note. But depending on the type of pacemaker you have, the majority of them do not send out an alert. You can have one that's called, no shit, my research is gone. I think it's called like an ICD. Don't quote me on that. But I think it's called an ICD. And that one can alert that it's no longer like a functioning thing. I wish I could remember what it was called. But anyway, so that's still up in the air. So still total mystery. He died in not an IUD. Do it, R&M. Steal them all. But so he was found dead in the mudroom. She's found dead in the bathroom with a space heater nearby somewhere. And then with pills that had spilled over. And then her German Shepherd, which was one of 3 dogs, was also found deceased. The other 2 dogs completely fine. And then there was like a huge thing about people wanting to have the dog to have an autopsy. What's it called? A necropsy. Necropsy? Yes, it's an ICD. Thank you. Okay. And so people are pissed and writing into law enforcement that they didn't do a necropsy on the dog. And I was like, okay, I get it. I mean, how did the dog die? It might help solve the rest of the crime or whatever. It's still just determined as a suspicious death or suspicious deaths. So I just thought it was interesting that the public is writing to law enforcement requesting that this German Shepherd have a necropsy. Autopsies and ice cream for everybody. I know this is how these lives go. One thing leads to another, and yeah, they were married for 30 years, but he was 95 and she was 65, but they were married for 30 years. And now that people are pissed off because the daughters were the next morning were just out eating breakfast and laughing and having a good time, and why nobody ever bothered to know that these people had been dead for almost 2 weeks. Nobody had called them, nobody had gone to check on them. And then there's the whole side conspiracy that she was the wife was super controlling, and that's why he moved from LA to New Mexico, and that she controlled everything that he ate and everything that he did. I don't know. So it's a whole big rabbit hole on this Gene Hackman thing, and I can't get out of it. It's the craziest thing. I think it ended up being 9 days that they had determined that his pacemaker had stopped working to the time that they were found. I think it was 9 days, but it was almost 2 weeks. They were mummified. Yes, they were. Yeah, they were mummified corpses. But the daughters had originally come out and said, oh, it's okay. Like, we think that they died from like carbon monoxide. And they made like a whole statement about it. And then all of a sudden, like, they ruled that there was no carbon monoxide found in their autopsies. So, DB has a uterus. I'm not really surprised, to be honest with you. And that he collects them, that wouldn't surprise me either. Dwayne Johnson went to McDonald's and asked for ice cream and was told it was down. He pulled out a $100 bill and said that was going to let them keep the change. He was going to let them keep the change. The miracle happened instantly. That's funny. I would not be surprised. Maybe if they had nearby neighbors, though, someone would have heard it. German Shepherd yowling is a crazy loud. That's true. Lack of water. The other dog could likely drink out of a toilet. Why wouldn't the German Shepherd be able to drink out of the toilet? It would be the bigger dog. No? I don't know. The dog probably passed from not being fed. But the other two survived. And I think it would take longer than 9 days. We got to know what happened. Yeah, it's just a crazy, lots of rabbit holes. The dog that died, I heard, was in a cage. I did hear that, and then I also heard that it wasn't, and it was laying next to her. So I don't have any. I went like really red. There we go. Oh, it's like psychedelic. I'm gonna make you guys think that you're taking drugs. Check that out. Whoa, that's crazy. I don't know what went on with the script. That was weird. But I heard the dog was in a cage, and then I heard that the dog wasn't. It was laying next to her in the bathroom. So I don't know. She was lying next to it. It was in a cage, both in the closet. I thought they were in the bathroom. See how, like, you can't even, I don't even know. Maybe everybody does need some ice cream after this. The dog was in the cage in the closet. And she was in the bathroom? That's true, Tom. Guess what you posted didn't show. Let me go see Kelt. I don't know. It was kind of bumping around, so it probably did, and I probably just didn't see it. I will go look. Oh, there it is. Hey, 13 months, Kelt. What? No way. It's been that long. 2 dogs were in puppy daycare. Only one was home. Okay. That is odd to me because supposedly the first responders saw the 2 other dogs and they were able to come in and out. So like the stories are not, nobody has the same story on what happened then. See, and Just Alice says one of the dogs laying next to her was one that was alive. Other was said to be out roaming the yard. That's what I had heard, that they were out roaming the yard. All right, I'm going to have to get some clarification. Yeah, Kelt, there's an article today saying the police admit they made an error, that they ran into 2 dogs roaming around. What? That doesn't even make sense. And if the other 2 dogs are in daycare and nobody comes to pick them up for 2 weeks, what? They don't have like an emergency contact? Like, how does that make any sense? Like, why are they at daycare? These are 2 people who live at home. They're older, retired folk. One's 95, one's 65. They're not gone. Because if they were gone, the other dog would have had to go to daycare too, right? Make sense. And then all of a sudden you just have like, you're the daycare and you're just like, I don't know, Gene Hackman's dogs are just here for like, they just drop them off and then they forget to come back and pick them up. And I don't have anybody to call. That doesn't make any sense to me. We are. I'm just catching up on other cases because I don't want to do full lives on them. So I just wanted to talk about it. This is Scott Peterson-esque, a German Shepherd on the loose. That was a golden retriever. No, was it a golden retriever? Shit, now you got me questioning myself. I think it's a golden retriever. Some have shuttles. Yeah. Okay. The last case before we go into Delphi. Todd Mullis. So we had talked about Todd Mullis, the corn rake killer from Iowa, and his post-conviction relief hearing that was last week, and it wrapped up yesterday. She now has, she's given the attorneys until 3/31, March 31st, to get in their briefs. I think there was the defense that requested it be April 8th. And then once she gets the briefs from both sides, then she will sit down to make a decision on Mullis, M-U-L-L-I-S, Mullis, Todd Mullis. And she'll make a decision on whether he can get a new trial or not. So I figured we do have some time. So I was putting together some playlists so that we can go through and watch the OG trial. And then we will watch the post-conviction hearing. And we should have time to watch all of that before Karen Reed starts and before we get an answer on whether he gets a new trial or not. I guess I do have one more case because we also had Karen Reed in court today. And that's always spicy. So, but that one I think we can do some lives on. So we'll leave that one for another time. So yeah, so it gives us enough time since she won't be making any decisions until after April 8th. I'm gonna get it all together, and we'll do like a rewind and watch his whole original trial. I'll do my best not to do any spoilers, and then we'll watch the post-conviction relief. It was 6 days of testimony. So. Can someone explain Todd Mullis's hairline? What's wrong with his hairline? I didn't notice if there was something wrong. Okay, police initially said the couple's German Shepherd named Bear was found dead in its kennel inside the home, but the pup was actually alive and healthy at a pet daycare center in Santa Fe, along with their other dog, Nikita, a 7-year-old Akita Shepherd mix, according to Today. Okay, that just absolutely makes no sense to me. Maybe I will have to do a Gene Hackman live. I don't know. I had to rescue a chicken from Tasmanian devil trapped in the chicken coop. This was in Tasman. Okay, I don't even know where that came from, but that's fucking crazy. Okay. I think that we've covered everything I wanted to talk about beforehand. Yeah, you just make up that you saw dogs. Like, oh, I just randomly saw these dogs. There they were. And then, oh, oopsie, I never really saw any dogs. It was all just make-believe. Where's Sleuthy? She was in here. Can't say shit about anyone else that the prosecutor's hairline is the most fucked up I've ever seen. The prosecutor's hairline in that case is that it's not even. I don't even know. I don't like. Do you do it like a sing? He has a major comb over. It's like, do you do like one? He does like one strand at a time, and it's like, I wonder how long it takes him to do his hair. It's like 1, and then 2. But I don't know why anybody does that because like you can tell you're bald. Like it's not real. Like how do you go to the hair like the barber and be like, okay, so leave just this one line right here, like really long, so that I can push it over here. It's so dumb. That's the Todd Mullis prosecutor. It's so bad. It's so bad. It's like literally one strand at a time, so you can still see exactly how bald he is. He probably does need plugs. If he's going to try to fake it, I mean, he's definitely never going to make it. So, all right. Just the one line. He's got just one long line of hair. Remember when he's got bedhead? It's just like this whole one little side is just all knotted up. It's just like a little tiny ball of hair. He's like, oopsie, let me brush my hair. Let me brush my one little line of hair. I have a child's imagination, I swear. Just a braid, just fucking shave it. Maybe he should get a hold of Nick and he can give him a referral. I want chocolate truffles. Who dis? I love chocolate truffles. Hey, Callie. Aww. Don't dox me. That's so sad. Why? But it's just like you're bald, honey. Like, just let it go. Let it go. Okay. Oop, that's Idaho. Sorry. I've got multiple things happening in the background over here. So it is what it is. Okay, so first things first, I think you guys have all seen that Twist Media put in their second and third, apparently. I don't know if the third is any different than the second, but it looks the same to me, so I don't know. But they put in their request because remember, Goal had denied it and said she needed like specific exhibit information, and if they wanted to request it, but it was like, how is everybody supposed to know what the specific exhibits are when barely anybody was writing that down in their notes? But I have a very good guess on how they got this. I cannot confirm it, but maybe if that person is here, they can confirm it. So they put in their second amended and literally just said, hey, based on the denial and the request for individuals, it's NBC. Finding the NBC and Twist Media LLC's request for public trial exhibits were vague and overbroad and do not request with specificity what is being requested. Conditionally granted NBCU's motion to intervene and to compel access to public trial exhibits, and conditionally granted the general public's motion to intervene and required the submission of specific particularized requests for the court to consider and accommodate appropriately. So they go through all of this, and then they send in this list that looks really fancy, like they did a lot of work, right? So entered on 10/18, here's day one. It's the drone video. Exhibit A, like, so they said like they don't know what the exhibit is. It's like XA, one Snapchat photo of the girls in the car, one Snapchat photo of Abby crossing MHB, and they go straight down the list of all the things. Well, this is quite an interesting list because somebody we know had made this list. It's very, very particular on how everything was in here. So I don't know if this was just taken or if somebody just used it as a reference, or if it was somebody asked like, hey, can we use this because it's the best list that there is. So, a friend of the channel here actually already has this beautiful list that we've gone over when we've been talking about exhibits from Delphi. This has been put together based on any information from anybody in the courtroom who was, happened to be taking notes of, exhibit numbers. And it's quite interesting that this list is very similar. No, friend of the channel, a friend of our channel. But you can see, here's all the exhibit numbers. So I'm just hoping that somebody actually said, hey, we're going to use your list because you've done such great work and thank you. And we'll give you a copy of everything we receive based on the fact that you did this work that we just used to get access to everything. Now, I don't know if that's going to be the case, but that should be the case, in my opinion. So I'm not going to go too far into that. I know a lot of people yesterday on the internets were going through like item by item. I'll just say we've already done that because we already had the exact same list. from our friend. So not something that we actually need to go over. Oh, I have hypothesis. Like, look at number 90. LG phone, or number 90 is photo of the back of LG's phone. 91, 191. LG phone with case on. LG phone with case off. So, anyway, like I said, if she wants to tell you that the list belongs to her, she's posted it on Twitter, so I'm sure she wouldn't care. But that's just my side comment. I will give you guys the OG list, but like you said, you guys have it from the motion that was put in yesterday anyway. Okay, hold 1 second. All right, I'll be right back. I don't know if Sleuthy wants to come up, she can come up, but other than that, I'll just give me a minute. I gotta go take care of this tiny human situation, and I'll be right back. Sorry for the delay. Okay, sorry about that. No, he did not get the ice cream. I had to take care of something else. Not give again. I'm a tough mom. Right? Yeah. My husband would laugh at that. Okay. At the end of this, if you guys want, we can go through this line by line. But like I said, we've somewhat done it before, but we can do it again if you want to. But here's the major reason we're here today. So we have a response to Nick, which we just read Nick's response on Friday. So now we have a response back to Nick. Well, it's to the court talking about Nick. And it's a very interesting read. I'm sure you guys may have heard this already today. Hey, all eyes. Ooh. Okay, good. That makes me happy, All Eyes. Thank you. I'm glad that it was not just taken off of Twitter, and I would have made the arrangement though, All Eyes, like if you get anything, I do expect a copy of it though. Just an FYI. You need to work out some type of deal. I mean, there's a lot of work that went into that. But I guess if they release it, then it should be easier for us to get it. We can just do a copy paste of their entire motion. It would be like, you gave it to them, now it's our turn. Okay. So comes down Richard Allen by counsel and files this reply to the state of Indiana's February 28th, 2025 response to Allen's motion to preserve and produce, and also requests sanctions for the state's violation of Carroll County local rules concerning exculpatory evidence. In support of said motion, Allen's states the following. The prosecution's response brief provided proof that the state of Indiana failed to turn over exculpatory evidence over to the defense. In his response, the prosecutor just glosses over the fact that he was in possession of letters that he failed to turn over to the defense before trial, even though on February 13th of 2025, in an email, he denied possessing such letters. McClelland also has no explanation as to why a letter from Davis from October 15th is missing and cannot be found. It's just like more shit that you have that you can't keep fucking track of. You did not learn from any of your prior mistakes. Instead, the prosecution spends the majority of his response denigrating, which is essentially degrading the defense counsel. Prosecutor McClelland is not the arbiter of exculpatory evidence or whether he has an obligation to turn it over. This has been an argument this entire case, is that McClelland constantly thinks that he has the right to say, this is not considered exculpatory because I said so. That's like the whole philosophy of the prosecutor's office in Carroll County. Because I said so, you can't have it. Because I said so, it's lost and you can't prove it. Because I said so, we can't find the attorney even though we already found the attorney. Because I said so. Like that's his motto. The law is the arbiter. Exculpatory evidence is defined as evidence tending to establish a criminal defendant's innocence. This Carroll County local rule also requires McClelland to turn over exculpatory evidence, and based on his February 28th, 2025 filing, we now know that the state of Indiana had certain letters in its possession on October 2024, but failed to turn those letters over to the defense until February 28th, 2025. The prosecution only produced those letters after the defense sought those letters. Another very common theme throughout this case. Defense finds out something, they go in search of it, and then they're like, oh, yeah, we did have something like that, but it's no big deal. It's no big deal because we said so. The prosecution only produced those letters after the defense sought those letters, but being forced to file a motion to produce those letters after the prosecution failed to admit being in possession of those letters. This behavior of the state is consistent with a pattern of behavior that has greatly impacted the defense and Richard Allen's constitutional rights throughout the entirety of this process. As will be recounted later in this memorandum, a pattern of withholding exculpatory evidence may lead to a reversal and a new trial. In Pruitt, the Court of Appeals reversed the conviction when soon after the conviction, the defense counsel learned of evidence that the prosecutor failed to turn over to the defense prior to trial. So the defense theory. At Allen's trial, the defense indicated that the evidence supported that on February 13th, 2017, the victims were abducted, taken somewhere else, perhaps in a vehicle, and then during the early morning hours of February 14th, after the search parties had left the area, were ultimately transported to the location where they were found on February 14th, 2017. Further, the defense's theory was that evidence strongly supported that multiple people were involved in the abduction and murder of the victims. The defense theories were detailed in the defense's opening statement and throughout trial or in offers to prove from August 1st of 2024. The state's theory was that in some order, the following events occurred. The killer, acting alone on an unseasonably warm day, after running or briskly walking across the bridge to catch up to the girls since he was not seen in the 207 photograph anywhere on the bridge, was seen on video, walking casually and not panting like a 45-year-old man who had run across the bridge. Then abducted the two victims, walked/slid down a steep hill with those victims. Then in a panic after observing a van, corralled those victims across an active creek while holding a gun. And then both victims somehow were undressed, but the younger victim was later redressed in the pants, bra. I thought this was interesting because we still, even after trial, never really got clarification on this whole bra situation. And the sweatshirt of the older victim, and the lone panicked killer murdered one victim and then murdered the other victim without anyone hearing any screams, in spite of the sound traveling very well throughout that area all the way to the bridge. Then the lone panicked killer moved the older victim from one area to another area next to a tree without any drag marks, indicating that he carried her from one place to another. All that activity, according to the state's theory, occurred in a 19-minute time frame between 2:13 and 2:32. When the older victim's phone stopped moving, having been placed under a shoe under the younger victim's body. After the murders, the state's theory was that this panicked killer then took time to place sticks on top of the victims' bodies, in particular patterns as depicted in photos admitted at trial, and then in spite of his panic, hung around the crime scene for over an hour before exiting the crime scene northward near a cemetery before this panicked killer chose to walk westbound toward his vehicle on 300 North in a bloody outfit, knowing that he would be in full view of any vehicles traveling that road after having killed the victims an hour and a half earlier. The state's theory was not that multiple men, women were involved in the crimes, but one man alone committed all these crimes, all these acts, and did so on the afternoon of February 13th, 2017. I mean, we've gone over this so many times, it doesn't make any sense because that is exactly the problem. The state continued to say, like, he got so scared that he ultimately didn't end up essaying the girls and just killed them, but stayed around long enough to make sure they were both dead, and then doesn't bother to go and leave the area, even though he knows he just killed two girls, and then a van drove by because he's so panicked and so freaked out, he just stays there until 4 o'clock and then walks the main road. It's just silly. Mav, I absolutely agree. Sarah Carbaugh has always been, to me, just such an unreliable source. And then learning what we did learn at trial about her, I really do believe that she was like, oh, look, there's a reward. And I saw something. So I must go tell. Okay, so the Reese Davis letters provide exculpatory information that supports the defense theory and negates the state's theory, and also provides other information that the defense could have utilized for trial or to support its request for third-party suspect evidence to be admitted into evidence. So even if you go with Nick's whole thing of he didn't get them until right before trial, they would have been able to use those letters for third-party, a third-party motion during trial. But we know that there's more letters and more information about Reese Davis that was done long before 2024. And Reese says there's 7 or 8 letters. The time frame on the letters that Nick requested from the DOC, I think, was beginning of October 2024 till the end of January 2025. So we have no idea how many letters were sent to Nick or any other prosecutor before that. In Davis's letters that the state of Indiana did not turn over to the defense before or during trial, Reese Davis stated that Keegan Klein, a key suspect in the case, confessed to the murders. A key suspect confessing to the murders is exculpatory evidence. remember, the whole thing with Richard Allen's confessions is it's direct evidence, right? It's direct evidence. But all these other confessions from these other people, they're like, doesn't matter because I said so. So you don't need to be able to use them for exculpatory evidence. You don't need to be able to use them at all. So as it tends to establish a criminal defendant's innocence, at minimum, Carroll County local rule required McClelland to immediately turn those letters over to the defense, even if he, McClelland, believed that the letters did not need to be turned over because of Davis's claim that Richard Allen was involved in the crimes alongside Klein and Logan. When police or prosecutors conceal significant exculpatory or impeaching material in the state's possession, it is ordinarily incumbent on the state to set the record straight. So the question is not whether the defendant would more likely than not have received a different verdict with the evidence, but rather in its absence, he received a fair trial, understood as a verdict worthy of confidence. So here's footnote 1 with Klein and Logan. McClelland's claim that he was not obligated to turn over the letters because of Davis's claim that Richard Allen was involved is not a judgment call for McClelland to make. Richard Allen was at home on the evening of February 13th, 2017, and the morning of February 14th, 2017. According to Davis's letters, and this is, people don't think that that's important, because if that's actually what happens, and that's what, there is some movement or one taken away and then brought back or anything along those lines, people constantly ask about Richard Allen's alibi, and that's actually when he does have an alibi. So according to Davis's letters, Klein indicated that Allen was with them during that night and morning, assisting in the murders. It is McClelland's obligation to turn over exculpatory evidence to the defense and let the defense determine how to proceed. Not in Carroll County, it's not. Because Nick said so. So the jury in Richard Allen's case was out for nearly 4 days, a very lengthy deliberation period. But I think it was like 17 hours. I think once we added it up, I think it was like right around 17 hours. In this case, Keegan Klein's confession to the murders and also Klein's claim that Ron Logan was involved are clearly exculpatory statements. These were the two most likely suspects during the investigation. If it could be shown that they knew each other, that would be a significant fact for the court to consider when determining matters of the third-party suspect defense, and also for a jury to consider. The fact that Klein also implicated Allen would not have been of concern of the defense, as the defense knows that Allen had no linkage to either Klein or Logan, and also because the evidence supported that Allen was with his wife the night of February 13th and the morning of February 14th. When Klein is claiming Allen was with Logan and Klein committing the crimes. Had the defense known of the information contained in the Reese Davis letters, it would have renewed its motion for third-party suspect defense regarding Klein and Logan and would have further investigated these claims. Perhaps the defense would have sought a continuance to investigate the ties between Logan and Klein. The defense could have argued that Keegan Klein knew details of the crime that no one else knew, and furthermore that he, Klein, was protecting an unknown third party by claiming that Allen was the third party after Allen's arrest. The defense could do none of that, as well as any other number of legal, strategic, procedural maneuvering if the defense, was in the dark about the contents in the letters while the prosecution was fully aware of the information. The details that Klein provided to Davis add to the exculpatory value of those letters. On page 4 of one of the letters, Davis claims that Klein detailed that the girls' bodies were moved 3 times and that they were not killed where they were found, and furthermore, that their bodies were staged. These are facts consistent with the defense theory and facts that oppose the state's theory. Then we talked about this on Friday too. Like, how is it not exculpatory if it goes against everything that you're saying? I'm not going to use it at trial, so it's not exculpatory, according to Nick. But it's like you'd have to change your entire theory of the case, because you're saying only one person did it. If you want to say that Rick was involved, which we know now post-trial, in the press conference, he literally says, we haven't cleared anybody. I guess I'm just so confused on why nobody bothers to investigate any of these quote unquote confessions. But then Rick just says whatever the hell he says, and it's just like, well, Rick confessed. And then we put out to the public, look, he confessed over 60 times, which they count as every time he brings up the word killed the girls, which is like, I don't know why I'd tell you that I killed the girls if I didn't do it. That's weird to me. When did I say that? Why did I say that? So why is it not like because this person who this goes back to like the whole like Holman's philosophy on life. I think you're a good person, and then Rick's like, well, you just told me you think I killed 2 girls. What kind of good person does that? Like, you obviously don't think I'm a good person. You think I'm a murderer. So like this is like the same thing. It's like, so Davis can say something, and it's like, oh no, Davis, you're not credible. You're just a big liar. And then, but Richard says something, and it's like, no, we'll believe you. But yet we think you're a credible person, but we still think that you murdered 2 girls. Like, and this is like a situation I kind of throw out there all the time. Like, I can go into a police station tomorrow and I can say I killed my neighbors. They can try to detain me, but they can't arrest me for murder because there's no proof I did any of that. They have to actually go and investigate that and say, okay, let's go see if are her neighbors even dead? 2, were they murdered? And 3, can we prove that this person who came in and said they did it actually did it? But it's like they just pick and choose. So it's like, what did they do? What was done to investigate any of these people that are coming forward? Like, Keegan Klein's the only one that I somewhat believe that they actually went through and investigated, only because they wasted $1 million on the confession of the Wabash River. But I don't know what else they would have done to even investigate what Reese Davis says. They're just like, well, he's a liar because we took our pocket polygraph in there and gave a man with Tourette's syndrome a polygraph, which you're not supposed to do. Hi, Carrie. Nick is good at talking out of both sides of his ass. Oh God. Oh shit. Why wouldn't they investigate? Either they don't care or they already know and don't want any of it on paper. So why? Also, are you still on the fence? I haven't been on the fence since trial. I guess if you want to talk about what, I'm 100% not on the fence when it comes to the fact that this prosecution railroaded the defendant. I don't know how I could say one way or the other anything about Richard Allen, because I think that the entire investigation or the evidence that they have presented to us is so tainted that I don't know how anybody can just say, yeah, he absolutely is guilty. These people have lied so repeatedly. I don't trust anything that they say. So do I think that he's like factually innocent and he didn't do it? I lean more that way, yeah. But I would still say, I don't think I'm on a fence. I would lean more that way simply because I don't trust anything that they did. But I 100% believe that he should have been found not guilty based on the investigation and the evidence. I hope that makes sense. Legally, he should not have been found guilty. This is my whole thing kind of just goes back to the fact that all they've done is lie. So even these like 5 main points, like they keep, all the really pro guilters of, Richard Allen's absolutely guilty. All those people, they bring up like 5 key points. God damn it, Thomas. Did I? Shit. I didn't even notice. They bring up these 5 key points of why they believe that Richard Allen is guilty. And all of those come from people who fucking lie all the time. And it's not like we don't know they're lying. we're catching them lying. We can prove that they keep lying. And yet it's like, well, we trust them on all of this stuff. It's like, no, we don't trust them at all because they keep lying. When you have somebody who pathologically lies to you, you can't even believe that they're telling you the truth when they are. No, I don't, Susie. And I don't care. I don't even know if Reese's, I shouldn't say I don't think Reese's telling the truth. I wouldn't be surprised that Keegan Kline, who is a pathological liar, goes in around saying how tough he is and he's such a tough guy and this is all the things that he's done. So I wouldn't even say that I think Reese's a liar because I don't necessarily think that. I think Kline is a liar. I've always thought that Keegan Kline was a pathological liar. This whole like admitting to being there and doing it's always bothered me because I'm like, he did not fucking go down any hills. He never would have gotten back up a hill. He'd still be there today. Like he never would have been able to get out of there. Like, so is Keegan Kline lying to Reese Davis? Fuck, maybe. Yeah, I don't have any thought process towards Reese Davis one way or the other for me. Like what I really have a problem with is the fact that this is evidence that should have been turned over to a defense team and wasn't. So I don't want to say that I think Reese's lying. I think Keegan Kline could very well lie to Reese Davis. And then Reese Davis is like, I'm trying to do the right thing here, guys, but nobody wants to fucking listen. Like MP being at the marathon at noon when he should have been at work, but the clerk kept the receipt until she died in 2018. See, KLL, that's not even something anybody even really talks about anymore, which is interesting because one of the things that was supposedly found at the crime scene, that was rumored forever was this Gatorade bottle. And then like that whole thing comes out about that Mike Patty actually was at the marathon at noon buying Gatorades. But that just goes away because so we don't know anything about it. It just is there and then it's not. So was it ever true? Is it a lie? Is it, who knows? Right. That's kind of where I'm at. Thank you for summing it up for me, R&M. Much more to the point. But that's really how I feel. It has nothing to do with Reese. And I'm not, like I said, I don't even think that it has anything to do with his credibility or not. Because I wouldn't be surprised that the liar lies to him. It was 2 pops. I thought it was a Gatorade, KLL. I'm almost positive they said there was a Gatorade bottle found there because that was part of the whole thing that they said was a potential to the DNA. But maybe it was 2 pops and I heard incorrectly. Okay. I don't even know where I was, so I'm going to kind of start this over here. The details that Kline provided to Davis had to add to the exculpatory value of those letters. On page 4, one of the letters, Davis claims that Kline detailed that the girls' bodies were moved 3 times. I already read that, right? Yes. Furthermore, in the letter, Davis claims that Keegan Kline detailed how the killers got nervous. Oh, here it is. This is where I was. So for me, the whole thing has to do with the fact that they don't turn these letters over to the defense, which completely destroys the state's theory of events and also could absolutely alter the defense theory or have given them the possibility of actually bringing third party in based on this evidence that Nick deems as not inculpatory because they're not using it at trial. For the ones who claim he's guilty, show me a real life or on YouTube licensed attorney who thinks he's guilty. All I found were fence riders or not guilty. Yeah, I think any attorney that's part of like LawTube, I don't know if I've heard anybody think that he should have been found guilty or that gives any credibility to the prosecutor besides the prosecutor's podcast. which I don't know, does that count? I mean, it's still social media, so I think it would, but I think that they're the only attorneys, and I could be wrong. I mean, obviously don't follow every attorney that there is. Hold on, I'm just checking comments real quick. They just don't play by the rules. They make up the rules as they go along, and they're constantly changing. Right. That's 100% true. It's like, well, we want to follow this law. True. Isn't it one of them is like, is that one of them, or was it the other podcast? One of those attorneys has never actually been in a courtroom. Well, maybe they've been in a courtroom, but never actually tried a case. Yeah, that's CW. That's what I had heard, but I don't know. There was one of the attorneys from that whole thing. Well, I guess the other one technically is an attorney too that thinks he's guilty. So like you could go with that. You could go with the shits version of attorneys who think he's guilty. So there's three. There's three attorneys that I know of on social media that claim he's guilty. Hi, Dan. Neither Brett nor Alice. See, I don't know that. I think I get the one confused with the other. I've always heard that one of them never had, but I've never looked into it myself, so I have no authority to say that for sure, but I'm sure somebody here has. Okay, so furthermore in the letter, okay, here. Furthermore in the letter, Davis claims that Keegan Kline detailed how the killers got nervous and left town in their own cars, with at least one of them going to Lafayette to get rid of evidence. Well, also in his other confession, remember he says that they threw the weapons out into the Wabash River. It is known that Ron Logan went to Lafayette at some point in time to purchase exotic fish. After having asked a relative to assist him, Ron Logan, in creating an alibi. These are all facts that Reese Davis would not know, but that the killer would know. All of those facts tend to establish Richard Allen's innocence. Because right after well, I guess, see, this is tough because you can't have your cake and eat it too here, where you're saying that the girls aren't actually killed right then, that they're taken back to either Ron Logan's or somewhere else, some barn shed, whatever, and then killed later and brought back. But then saying that Ron Logan went to Lafayette at some point because he goes that day to purchase fish, that he would have gotten rid of evidence. I guess maybe he got rid of whatever evidence there would have been to that point. I don't know if this would really fly. Hold on one second. Okay, sorry. Now I got another kid who's talking about gymnastics practice. So I don't know if this would really work, because if you're going with the fact that Keegan's telling the truth about that they're not actually killed till later, there would be no evidence to technically, I guess there may be, like I said, whatever evidence gets you to that point, I don't know, to get rid of the evidence. It is known that Ron Logan went to, we already know that, and all those facts tend to establish that Richard Allen is innocent. In the second letter, Davis claims that back in 2018, Davis, reported that the victims' throats were sliced. This is something that only the killer would know, especially when the details of the murders were not known at the time. I disagree with this. Because in 2018, we do know for sure that not only had their funeral happened, which they were wearing scarves and everybody was speculating that their throats were sliced, but also Erskine, who was at the crime scene, had already entrusted his conversation with somebody who plastered it all over social media, where he also talks about that. So I won't agree that that's something that only the killer would know. Not in 2018. If that had been closer to like the March, May of 2017 timeframe when Logan was arrested, I may believe it more. But 2018, I think it was pretty common knowledge or pretty well assumed across all social media that that's what had happened. Okay, so he also stated that he reported that the girls were hidden in a barn and also driven around at some point in time. This is consistent with the defense theory that the girls were driven in a car at some point and held somewhere until the search parties had left the area, and inconsistent with the prosecution theory. On page 3 of that letter, Reese recorded that Keegan Kline told him that the scene was staged and furthermore mentioned that the girls could not be moved because the search parties were everywhere throughout the night at that time, meaning that the girls were moved to the place they were found only after the search party left the area. This is just as the defense claimed, thereby supporting the defense theory and negating the state's theory. I thought that too, Laura. That's what I thought too. But it's kind of hard to tell because this is supposedly 2018 now. So maybe it's just multiple claims. Maybe in 2018, when he still is trying to contact Nick, he's still stating the same thing. Because I swear that one of them we had talked about that it was in May of 2017. Hi, MOD. Right, which they did in the other document, in the other motions. Gen P, that's pretty much my life now. I hope you're feeling better, by the way. Confidentially incorrect is the thing that gets my goat the most. The manner of the cut, though. Yeah. Keegan thought Reese was a pedo, then maybe he could have some truth, maybe. If the problem is you can't trust him, so you'd have to go and try to figure any of this out. And at that point, I don't think in October of 2024, Nick doesn't care. Nick doesn't care if anybody else is involved because he got his guy, whether the guy's the right guy or not. He didn't care about that. His plan when he was elected was, how does he state it in the press conference? Because he essentially says it. When I became the prosecutor, my goal was, and I'm not going to quote it correctly because it's been a while now, but my goal was to arrest and prosecute somebody for this crime. Like the way that he says it is, it didn't matter who it was. So I don't think that he actually gives a shit that there might be other people out there. So he's never going to go investigate any of this because he's going to just say, Reese Davis, not credible. Keegan Kline, not credible. And Ron Logan, too bad, so sad he's dead. So none of this matters at all anymore to him, which is why he's not going to use. He wasn't going to use it at trial. He wasn't going to turn it over. He wasn't going to tell anybody about it because it just doesn't matter to him because he said so. Hi, holy shnikes. I hope you're doing well. I don't bother to watch them, Jen. Yeah, I don't either. I just unsubscribed. I wonder if Ives has any Reese letters. Right, exactly, music. Exactly. On page 3 of that letter, Reese recorded that Keegan Kline told him that the scene was staged and furthermore mentioned that the girls could not be moved because the search parties were everywhere throughout the night at the time, meaning that the girls were moved to the place they were found only after the search party left the area. This is just as the defense had claimed, thereby supporting the defense's theory and negating the state's theory. In his February 12th, 2025 interview at Newcastle Prison, Reese Davis provided further details that Davis claimed and / believed that he also provided to the prosecution concerning details that Keegan Kline stated to Davis. In that interview, for example, Reese Davis claimed that Keegan Kline stated that the girls were handcuffed to each other. Ooh. After the meeting, defense counsel Ajay Baldwin and investigator Matt Hoffman viewed the crime scene and autopsy photos to determine whether there were any indicators on the victims' wrists that would support this new information that the victims were handcuffed to one another. The admittedly non-expert eyeballs of the attorneys and investigator observed straight lines on the left hand of the wrists of both girls. Huh. Which, if true, could indicate that one victim walked immediately behind the other with each of their hands handcuffed to each other so that they could not easily run away. If the defense had received these letters, it could have learned these facts from Davis during a deposition, if they weren't contained in the letters, and then had experts view the same photos to determine whether the photos were indicative of the girls being handcuffed. That's interesting. So left hand and left hand. So they'd have to either be front, like one behind the other, or they'd have to be facing opposite directions, like facing each other, right? Yeah, in a line, because if they didn't have that info about them being handcuffed, there'd be no reason to bring it up, right? I think the whole point is they don't know what they would have done because they didn't have the information. That they're just telling the world now, like, if we'd had this info, we could have done all these different things. But because they don't tell us this stuff, we don't know which way to go with it because we didn't have the info to make a decision. And now here we are, two attorneys and an investigator trying to look at crime scene photos to see if there's actually handcuff marks. It's still weird to me that nobody's brought this up. No, not that part. I thought you were talking about the line on the face. On Abby's face. The line on Abby's face. Had the defense known of the Keegan Kline statements to Reese Davis, it could have brought both Keegan Kline and Reese Davis in for a deposition after hours or during the weekend while the trial was occurring. These depositions could have revealed additional information, including whether at some point in time Keegan Kline finally admitted that Richard Allen had nothing to do with the crimes, as Reese Davis stated to counsel during a jail interview on February 12, 2025, and also to show that Keegan Kline's claim about the activities of the third person involved with him, Kline, and Logan was inconsistent with Richard Allen's whereabouts the night of February 13th and morning of February 14th. The defense likely would have called upon Kathy Allen to show that Richard Allen was at home during that time frame and not with Logan and Keegan Kline. That was always my point. Like, people said that, you know, the defense should have put her on the stand. It just never really made sense to me. She really didn't have anything to offer. She couldn't be his alibi for that time frame. He was home alone. There was a belt found. Could it be from the belt? Well, that's a great question. I don't even know if the belt was ever tested for anything or if anybody ever figured out who the belt actually belonged to. And we've known for a long time that a belt was found, but is it like the handkerchief that's found and nobody bothers to, we're not going to test it because it looks like it's been out there for a long time? Additionally, the defense could have asked the Department of Corrections to provide video from the very pod where Reese Davis and Keegan Kline were housed to determine whether Kline and Davis were frequently talking with one another, as Kline has apparently stated in State's Exhibit 4 that Kline has only talked to Davis maybe 2 times. If the video shows that Davis and Kline talked to each other well beyond 2 times, then it would be determined that Klein was lying. Whereas, if the video shows that Davis only talked to Klein 2 times, then it would show that Davis was lying. Either way, the defense had a right to those letters to conduct its own investigation concerning the veracity of the contents of those letters. McClelland's claim that he did not turn over the Davis letters because he, McClelland, made his own determination that the letters were not in fact exculpatory, denied Allen and his attorneys the opportunity to conduct its own investigation from the information contained in those letters and to determine what to do, if anything, concerning the content of those letters. In his February 28, 2025 response, McClelland makes much noise about Attorney Baldwin attempting to put into the public domain information through the filing before verifying that information. It should be noted that Attorney Baldwin first attempted to work the matter out with McClelland via email before filing his motion. We talked about that too. Like, wait, you tried to actually confirm it. On February 12, 2025, Baldwin had emailed McClelland asking for the Reese Davis letters. And on February 13, 2025, at 2:41 p.m., McClelland responded as follows. This whole thing is kind of funny with this whole verified, like before verifying that information. This is, and this is like what Michael always brings up, is like, this is actually, this motion we're reading right now is a verified motion, while the ones that Nick files are not. So it's just kind of a funny side note that Nick wants to throw out verifying information, but doesn't actually verify his motions. So on February 13th at 2:41, McClelland responded as follows. The information that we have concerning Reese Davis was forwarded to you as part of discovery. You had every opportunity to call Mr. Davis at trial or at the hearing on third-party motive. You chose not to. Your strategy was not to call those people. The trial is now over. Richard Allen was convicted. If you feel you need to file additional motions, then file them. The state will respond appropriately. The state will follow any orders the court puts out in regards to those motions. This is the whole nana nana boo boo. You lost. So too bad, so sad. You can't have anything. Right? It wasn't just third party motive. It wasn't. They had multiple motions. It was motions hearings for 3 days. I will respond appropriately. I absolutely disagree because I said so is appropriate. But, you know, and he's like, I'll follow the orders the court puts out in regards to those motions. Well, yeah, because she's going to just be like, oh, Nikki, don't worry about it. We got you, boo. We got you. Before filing any motions, Attorney Baldwin made one more attempt to simply obtain the letters. The defense responded at 3:54 p.m. on February 13th of 2025. I mean, it's just ironic the date of this exchange, the irony of February 13th being that day, by asking McClelland whether he was admitting or denying that he, McClelland, had received letters from Reese Davis in the months leading up to the 2024 trial. Not to mention, here, the information that we have concerning Reese Davis was forwarded to you as part of discovery. Now, if we talk about the state responding appropriately, is that a true statement? According to Nick's own response? I mean, that's factually not true. But he tries to skirt it by saying, well, it's not discovery because I wasn't going to use it, and it's not exculpatory because it still says that Rick's involved. McClelland could have quickly answered the question and then provided the letters to the defense and perhaps avoided any more filings. So the whole narrative of the defense wants to just put everything out there in filings, blah, 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 is not true. Once again, another lie. McClelland also could have asked Baldwin to hold off on filing anything while he, McClelland, gathered the letters to turn them over to the defense. Instead, McClelland chose to ignore the defense's request, prompting the defense to file its February 14th, 2025 motion to preserve and produce the Reese Davis letter. It should be noted that the defense was seemingly up against a deadline of sorts. If the defense waited to file their motion, the judge might rule on the motion to correct errors beforehand, which arguably would prevent the defense's ability to file the motion to preserve and produce, as such a ruling would arguably kick the case to the appellate lawyers. Also note that in his February 13th email response, McClelland claimed to have provided the defense all the Reese Davis letters during discovery. This was simply an untrue and misleading statement typed on his computer and sent to the defense by McClelland. A true crime fangirl? What did Anna say? Problem with close family testifying, I think prosecution could wander and cross, such as, did you ever fight? Was he ever angry? Alcohol problem? Yeah, I agree with you. Her testimony is just unnecessary because the whole reason she'd need to testify would be to provide the alibi. Through his February 28th, 2025 filing, this court learned that McClelland actually was in possession of these letters on February 13th, which contradicted McClelland's representation to the defense that everything had been turned over. McClelland chose to intentionally mislead defense counsel about his possession of those letters. McClelland was getting called out by the defense once again, and once again, he was ultimately forced to turn over the letters. Perhaps out of fear that the defense would eventually gather DOC records that would then expose McClelland's misrepresentation. Okay, so we've got a couple footnotes here, so let me see. So 2, once again, is referring to the other times that McClelland was forced to turn called out by the defense, as detailed in the next section of this memo. Number 3 is Allen and the defense are not conceding that the DOC records that McClelland admitted as exhibits are proof positive that other letters don't exist. The defense has no idea how records are kept or how accurate those records might be. The defense also is not sure how McClelland was so quickly able to access those records from Newcastle. Certainly, as detailed above, McClelland's response to the motion to correct errors, in which McClelland provides details found nowhere in the Reese Davis letters, provides a compelling argument for the belief that either other letters exist or video exists that has not been turned over. It is such a fucking great point. Where in the heck is the documentation that he says that that somebody told him that the battery was removed and put back in later? Why did Nick just come out with random ass new info that nobody else fucking knew about? And where did he get it from? McClelland's misrepresentation has yet to be explained by McClelland to this court or anyone else. Are the letters McClelland finally provided to the defense truly the only letters and or videos in his possession? McClelland's recent response to the defense motion to correct error provides troubling statements that cast doubt on McClelland's claim that these are the only letters or evidence that are in the prosecutor's possession. In the prosecution's response to the defense motion to correct errors, in an apparent attempt to discredit Reese Davis, McClelland claims that McClelland, had information that Reese Davis had claimed that Ron Logan took batteries out of Libby's phone. This is curious. It's very curious because the prosecution has failed to produce any document or videotape in which Reese Davis makes such a claim. The defense has found nothing. This leads to serious questions of where did McClelland learn of this information? The defense is left with one of two possibilities. McClelland has additional Reese Davis letters, reports, or video from where McClelland, gained that information. Or 2, for reasons that we just fucking don't know, that McClelland just made up the story. It's just like, I don't know, there's something about a battery. I'll just put that in there too, even if it's not true. Where the hell did he get this information from? I like that for reasons that are unknown. McClelland just fucking says, this is what happened. This is a trust me, bro. Trust me, bro. Because I said so. Michelle says, Carroll County law enforcement, the prosecutor and the judge have violated not only the letter of the law, but the spirit of the law as well. It is sickening they would get away with this. I could not agree with you more. I could not agree with you more. He probably Googled it. He was like, Cecil, you get out in that hallway and you get me an answer. And he's like, I don't know. There's something about this battery. It could have been in and out. And it's like, Reese Davis told us the battery was in and out. That's what happened. Google expert. Andy was truly all of us when writing this. I just had a horrible image of Holm and Nick doing a pottery wheel a la ghost writing this up. He Cecil'd it. It's so crazy to me because, like, they do it. They like these filings. They do just end up calling each other out, and because for whatever reason, I shouldn't say for whatever reason. We kind of know the reason. They cannot communicate, and when they try to communicate, that's the kind of response that Nick gives. You know, this is not new. This has been ongoing the whole time. Like we're looking for the Purdue professor. We don't know if we're gonna find him or not. Oh, oopsie, Holman already found him and scheduled a meeting with him. Oopsie. It's the craziest shit to me that anybody believes these people. It's even crazier to me that there are people on social media who write to Keegan Kline with the expectation that he's going to tell them the truth. Like, talk about a proven, one, just a fucking weirdo, and two, pathological liar. Why would anybody write to him to find out fucking anything? He's never going to tell you the truth, ever. And even if he is telling you the truth, you're not going to know it because he'll never be able to prove it to you. It's like, that's crazy. It's like, Reese Davis over here, he's fucking lying. I don't know why anybody's talking to him. And it's like, let's get a hold of Keegan Kline because he'll tell us the truth. What? It's just like this whole thing. I feel like I feel like the whole fucking case is right there. It's just a made up story. The whole thing's it's just a made up story. And it's like, we'll see if it works. Nick quotes him like, oh, look at how reliable this guy is. He's, and he's even telling other people on social media. He's telling everybody. It's fine. You want to write to him and get an answer. I really don't have a problem with that. I think my issue more has to do with the believing him. Why would anybody believe him in order to say that another inmate is lying? Why not just go, hey, I don't trust the inmates. I don't trust anybody in prison who's telling anybody anything. And just leave it alone. You know what I mean? Like, don't say, how do you believe fucking Keegan Kline over anybody? It seems unlikely that such a specific story would be made up, leaving the defense to conclude that McClelland has additional Reese Davis letters, reports, or video, but has not turned it over to the defense. McClelland has not explained to this court, nor anyone else, from where McClelland claims he learned this information about the batteries. Nor did McClelland back up his story about the batteries with an exhibit attached to the filing. It was just a mistake. It was a mistake. I didn't mean to put that in there. It wasn't real. I was thinking about something else when I wrote that. Also note in that email that McClelland requested Attorney Baldwin to file something, which Baldwin did, only to have McClelland then cast aspersions about the filing. Oh, that's so true. File whatever you gotta file. I'll do what I gotta do. And then he's like, and he's just over here filing all this stuff so that it's all out in the public, so he can have this public narrative specifically on social medias. God, he's such a fucking gaslighter. I can't stand this guy. I cannot stand McClelland. He's just such a fucking gaslighter. I don't know if you guys have ever been friends or been in a relationship with somebody who's just so narcissistic and gaslights the shit out of you. I think you might see it easier than somebody who hasn't. I had a friend of mine who was like this, like just fucking tried to, but it worked. So I think that the difference is being able to see through it now versus then. You did Darvo? It feels like this is, and maybe that's the thing. It's like people who haven't been in any type of friendships, relationships with somebody who gaslights like this. Maybe this is why they buy it so easy, because this is their first time. You know what I mean? Yeah, he'd blame you if he cheats on you. That's the type of guy he is. Yeah, absolutely. For you, it was a parent. That's even more unfortunate. Looking back, I can see that in my life as well. But and you don't want to see it. So maybe because people are like, yay, they got their guy, the killer's behind bars, that they just don't see that McClellan is constantly lying to them all the time. I agree. I pay very close attention, very close to people's words, and catch things like that easy because when I was young, I caught on to it. See, I didn't. Mine was as an adult, and it was a friend, and she was just a pathological fucking liar and just gaslit the shit out of me for a long time, and I didn't see it. I didn't see it until it was too late. That's all I can say. And then you go back and you look and you go, holy shit. And I feel like I'm a pretty observant like person that I could, I would be able to, like, people don't really do that. You know what I mean? Like, I would be able to catch on pretty quick. No, they're fucking good, man. There's people out there that are just fucking good at it. Maybe she has, because there was some things that she did. Maybe she's that naive. Maybe she's just that naive. I don't know. I hate to see that when it comes to a judge. But she did go when she was doing the whole Buddha in October of 2023. She was doing that whole you lied about this and you did these things and you said these things, and the defense is like, what? No, we didn't. And then finally, I think it was like in the 3-day hearing or another one of the other hearings, I don't remember which one now, it was proven that the things she had accused them of was wrong, that she was wrong. And she never ever came out and was like, oh fuck, I said a lot of shit about you guys. Even in my orders, I said a lot of shit about you. And it wasn't true. Damn, fuck, sorry about that. That's where I see her now. I see her as what do you call it, complicit. Oh, I fucking hope not, CO Mama. Please tell me that's not true. I don't think so. They live in Indiana. That's how they go to everything. Silly Fergus has the hots for Nicholas. Maybe. I mean, he was an attractive guy in his younger years. I don't know whatever happened to his nose, but that's no longer the case. I wonder if a person is raised around people like that, do it themselves and don't realize it. Like, you think maybe he doesn't even realize he's a gaslighter? There's a really good documentary called Century of Self that goes into the advent of individualism and father of consumerism. Eddie Bernays, narcissism is partly a generational problem. Well, that's interesting. I'm going to write that down. Century of Self. Yeah, I mean, she just never even came back and apologized to anybody. Like, hey, I was really RNF. Okay, let me see where we're at. We still got more to get through. Okay, so McClellan's history of holding on to exculpatory evidence until being forced to or called out by the defense. Unfortunately, as has been the historical pattern of the prosecution, McClellan made the decision to hold on to those letters until called out by the defense, much like he had made the decision to hold on to other exculpatory evidence over the course of this case. Again, Indiana courts of appeals have commented on patterns of withholding exculpatory evidence and have even reversed convictions when prosecutors have exhibited such patterns. So number one, Steve Mullins claimed that the Brad Holder and Patrick Westfall and other crucial early interviews between 2:14 and 2:20 were recorded over was not relayed to the defense until 1:30 of 24, in spite of the defense asking for that evidence since August 10th of 2023. Okay, so let's break this down real quick, because they were put back on the case on the 18th, so like 12 days, and they were kicked off of the case 2 months later. So ironically, about little over 70 days, they didn't get it. I wonder if this was ever turned over to the other defense attorneys. As anyone in the criminal justice system knows, often the most important interviews are those interviews closest in time to the crime. Brad Holder and Patrick Westfall were on law enforcement's radar screen as suspects very early on in the case, a fact that is evident from reviewing emails all the way up the chain to Doug Carter in the early days of the investigation. Those emails were admitted as evidence during the July 30th to August 1st hearings because of law enforcement's very early interest in Brad Holder and Patrick Westfall. Each were quickly found and then quickly interviewed on February 17th, 2017, within 3 days of the murders. On August 10th, the defense first unveiled to the prosecution that the defense believed that the state's own evidence supported that Holder and Westfall were involved in the murders. From a single 2-page document found among hundreds of thousands of documents, the defense found evidence that law enforcement had interviewed Holder and Westfall on February 17th, 2017. And that both interviews were memorialized through audio videotape. It was after the August 10th, 2023 deposition of Jerry Holman that the defense began demanding those interviews, which the prosecution should have already provided to the defense. We've talked about this, that you have discovery deadlines based on when you have that information. So anything that you have at the point of arrest, there should be no reason that you don't immediately turn over. You already have it. It's already compiled. It's not new. The guy's not arrested until 2022. You have all of this put together, right? Like, that's what you should have. So it's easy. Like, most states, it's like 30 days post arrest. You have any type of evidence that you have, or any type of discovery that you have over, like right off the bat. But then he calls this not exculpatory anyway. Nick calls it not exculpatory in another motion after they filed that, regardless. So the Franks. Okay, so when McClellan and Mullen failed to turn over those interviews or explain what had happened to those interviews, the defense called out the prosecution in the Franks memo filed on September 18, 2023, footnote 66 on page 56 of the memorandum, details that the prosecution had failed to turn over the Holder and Westfall interviews that the defense had been seeking. Even after the Franks memo was filed and the defense alerted the court, calling out the prosecution for not turning over the Holder and Westfall interviews, the prosecution still refused to answer the very simple questions posed by the defense of, where is the Holder and Westfall videos? Please turn them over. And the defense heard crickets. Yeah, because Mullen supposedly knew what? Was it August of 2017 is when he realized all that shit was deleted? Why wouldn't they have just said, hey, FYI, all of this shit was deleted? We don't have any of it. There should be no asking for it. We don't have it. We have none of the interviews. Not just those two. We don't have any of them. They're all gone. Instead of immediately alerting the defense on August 10, 2023 that those videos had been taped over, McClellan and Mullen said nothing. Finally, on January 30th, 2024, the prosecution provided a document that detailed some of the contents on the certain hard drives that it had turned over to the defense. In the fine print on page 5 of this document, the defense finally learned what McClellan and Mullen were claiming happened to those crucial interviews they, quote-unquote, recorded over, along with all other crucial interviews between 2:14 and 2:20. So think about that. They've been on the case for a year, kicked off, brought back on, and they still did not know. Neither McClellan nor Mullen called the defense and said, hey, we should have told you this when you first got on the case, or at least back in August 2023 when you asked about it. But those interviews you have been seeking for the last 5 months were taped over in 2017. Defense counsel has practiced for over 30 years. During that time, if the prosecution in any other county ever received exculpatory evidence or learned that certain evidence had been destroyed, it would immediately contact the defense and tell them on the phone or in person that the evidence had been destroyed. In this case, the defense was lucky to even notice Mullen and McClelland's claim that the crucial video was taped over, as such information was sandwiched between other minutiae contained in a document. This should also not be overlooked. If, in fact, those crucial videotaped interviews were actually taped over, that would be colossal news that Mullen and McClelland would not have forgotten. Losing such evidence would be the talk of the unified command due to the serious nature and potential serious consequences of losing such important evidence. To lose such crucial evidence early on in the case would not be the type of thing that would ever leave the memory of the man in charge of that evidence, Steve Mullen, nor the minds of those in the unified command. Therefore, when the defense requested the prosecution to turn over those interviews, Mullen and McClelland should have immediately said to themselves, "Oh no, those interviews were erased back in 2017. I need to immediately tell the defense. I should have told them that when they got on the case, but I will do it right now." Nick's never going to say that. Nick's like, fuck it. Fuck them. I'm not telling them shit. It is inexplicable that Mullen and McClelland would not have remembered in August of 2023, when the defense first requested those interviews, that those interviews had purportedly been recorded over. Yet, neither McClelland nor Mullen told the defense of this earth-shattering type of news that Mullen had known for 6 years at the time. To make matters worse for Mullen and McClelland, when the defense finally learned of the so-called recorded over interviews, the defense asked if there were some documentation memorializing what exactly happened to those interviews and how it had happened that crucial evidence had been recorded over. Surely a report existed that would explain this terrible accident that caused crucial evidence to be forever lost. However, no such report had yet been tendered to the defense. Some point in time later, the defense finally received such a report. It was drafted by Steve Mullen. Or was it? Inexplicably, it was undated. Therefore, no one knows if the report was drafted in 2017 or sometime in 2024 or anywhere in between. That document was entered as an exhibit at the March 18th, 2024 motion to dismiss. This undated document is not normal, nor the normal way that law enforcement and prosecution operate. The question must be asked, therefore, why did Mullen and McClelland not immediately alert the defense that the Holder and Westfall and many other interviews were recorded over, when the defense first asked McClelland and Mullen for those interviews in August of 2023? And why did Mullen and McClelland not turn over the undated document purportedly explaining how the interviews were recorded over until after the defense requested that document? The defense has not seen anything other than an undated document in the words of McClelland and Mullen that support that the interviews were actually recorded over. This is not normal, and it is very troubling. Neither Nick nor Mullen, nor anyone else in Unified Command has ever explained this to the court, nor anyone else, why they did not immediately alert the defense that crucial evidence sought by the defense had been purportedly recorded over. Neither McClelland nor Mullen or anyone else has ever explained to this court, nor anyone else, why it took 5 months before providing a document detailing the claim of Mullen of what happened to those interviews. Those are 5 valuable months during Richard Allen's counsel could have been investigating the actual claim that those interviews were recorded over. This is not normal. I disagree, because it wasn't technically 5 months. They weren't on the case for part of that. It was 72 days, I think. For over 4 months, McClelland, so this is number 2 now. For over 4 months, McClelland held on to exculpatory evidence he had in his possession from Todd Click's lawyer, including a certified letter detailing how a law enforcement officer was concerned, essentially, that McClelland may have the wrong man charged based upon evidence that he, Click, and 2 other law enforcement officers had gathered over a lengthy investigation that led them to believe that Holder and Fields, and perhaps others, were involved in the murders. This is not normal. This is not normal. What do you want to ask? What do you want to ask me? Let me see, Kel. I was hoping it was a court filing. Reddit and 3 other channels, I think Prof discussed it. Okay, hold on. What are we talking about? That's interesting. Remember where you read that? Didn't they find the prepaid phone under the Monon High Bridge? They can track it from where it was bought and by who. Okay, so I'll have to bring that up. There was another phone they talked about finding somewhere in that area. It's on the list that Nick provided as an exhibit, but I don't remember all the details to it. But it's on that list in that documentation. Like he put it as an exhibit, and there's like, on this day we handed you over, XYZ on all these hard drives, and we had read through them. But I'd have to go back and actually check it. It was Exhibit 7, but I don't remember like where it was. But that's where that's the information you're discussing is from that. I just don't remember all the details. I have no idea who found it. I know that he claimed that he had found a phone not too long after the crimes, though. Hi, Luna. Yeah, I don't know if it has a. I don't think it has a date. I feel you, Kay. I feel you. Truth Seeker knows those details. Yeah, I just don't know if it's that phone, though. That's the only thing. I know he had stated before that he had found a phone. And then I think they also took his phone. But that's a whole... I think they took his phone at some point, never give it back. Johnny Messer, but I think you're right. So we're together sometimes. You guys, it's physically impossible those interviews were accidentally taped over. Well, supposedly it's like the DVR only held like 6 months or whatever. I don't remember what it was. It was something stupid, like the light was on, the light was off. Nobody knew that it was just continuously recording like an empty room. So like apparently they never brought anybody else in there to interview them and flip the switch on and off. I don't even understand it myself. Wasn't it the one fire department went to find under bridge after they got done searching under bridge around 2:30 a.m.? Are they the ones that found it? There was multiple phones that's talked about in that discovery dump. There's multiple phones they discuss. The other thing is, let's not forget, they only gave us that Exhibit 7 in regards to what was turned over the day in particular. That's not all of discovery. There's still more discovery that was turned over on other days that we don't have. So is there more phones listed on other parts? Absolutely. When devices run out of storage, they fail to keep recording, not record over stuff. We'd have to figure out what like DVR model they had and like do a whole test on it. Right. Yeah, some were taped over, some just don't have any audio. Well, and I don't know if they bring it up in this filing, but also this is when they're like, okay, did you keep a list of everybody you interviewed in order to go back and interview them? And he says, no, there was no list. But then when he goes to testify, he says, oh yeah, there was a list. And I think it was Baldwin who was like, wait, what? There was a list? You told us there wasn't a list. He's like, oh yeah, there's a list. I almost just feel like they, and this is just my thoughts, so you can agree, you can disagree, whatever you want. I almost feel like they know exactly who it was. They didn't want that person in trouble. They screwed up everything in hopes that that person would just never get in trouble. And then when the community was just becoming more outraged about the fact that there was still this unsolved homicide, and then you get Liggett who's trying to get elected, and they're like, perfect, we've got this guy, let's make it work. That's where I'm at with it, because I feel like they did. There's so much wrong that I just don't know if you can just go, okay, you guys are just really this stupid. Are you all really this stupid? I mean, I just like think of myself like, obviously I'm not a cop. I have a criminal justice degree, but I was a retail manager for 20 plus years. I just think we did, we had the big companies come in and do our inventory. If I had fucked up my inventory as a store manager as bad as they fucked up evidence, I'd have lost my job. And you're talking about products, not evidence that's actually going to convict a person of murder or could potentially get the right person. Like if I had screwed up so bad in keeping track of what I actually had in my stores, I wouldn't have a job. And yet here they're like, oh, let's get rid of the Delphi police chief and now we're going to bring in Mullen again, who doesn't know shit from fucking shit. Like, why, what? Yeah, here you get a raise and you get promoted. It's like the more you fuck up, the more we're going to take care of you. Thank you. So make that make sense, because it just doesn't.
Do I need to bring my keys? Or do I just leave the door unlocked?
No, you can just leave the door unlocked. That's fine. Yeah, just compulsive liars. But I almost feel like Nick does it to just cover his own ass. Bye, babe. Love you. I don't know. Could you just imagine, like, whatever job you have, that this is, like, it's okay that you just fuck everything up. And they're just like, yay, you're the greatest. And I'd walk on hot shards for you. You're so good. Get you a promotion. Again, I've lost my place. Okay, as this court knows from the Franks memo, including documentation provided to the court in that memo on May 1st of 2023, McClellan received through the United States Postal Service a certified mailing from an attorney, Paul Barada, that detailed why his client, Todd Click, was concerned that McClellan did not have all the information necessary before making an arrest. This certified mailing not only contained a letter, but also the actual evidence that Click and law enforcement officers Kevin Murphy and Greg Ferenczi had gathered during their investigation. This included several videos that the prosecution had never turned over to the defense from the likes of Elvis Fields, Rod Abrams, Ned Smith, and Johnny Messer. Again, in a normal world, this would be an earth-shattering mailing to receive if you were a prosecutor. Normally, this mailing would cause a normal prosecutor to immediately contact the defense attorneys by phone to alert them that the prosecutor had received this information that clearly was exculpatory. However, that did not happen. Instead, the prosecutor held onto the contents of that certified mailing for over 4 months. The prosecutor only turned those documents over to the defense after it became clear that the defense, would soon be learning of that certified mailing. In the August 10th deposition of Jerry Holman, the defense provided Holman and the prosecution with the 12-page Odin report, where the prosecution had to know that Click was a member of that investigation trio of law enforcement, along with Kevin Murphy and Greg Ferenczi. McClellan had to have understood that it was only a matter of time before the defense would learn from Click himself that he, Click, through his lawyer, had mailed a letter, much like Reese Davis, to the prosecutor with exculpatory evidence. McClellan's failure to immediately turn over this exculpatory evidence has never been explained to this court or anyone else. Why did it take McClellan over 4 months to turn over this evidence? Similarly, it took McClellan approximately 4 months to turn over the Reese Davis letters. Delayed discovery of exculpatory evidence without explanation is not normal, but has been a consistent pattern in this case. I really liked Michael's question earlier about, was the FBI ever made aware of Reese's combos with RL and subsequent poly interview letters? Methinks probably not, right? I'd be curious. I'd be curious how much was kept from the FBI. I don't know if we can say really one way or the other, but I would be curious to know. R&M didn't show up to her live? Okay, so number 3. Hey, Richard. Hi, Heather. Hold on. I canceled it in StreamYard, but for some reason it didn't cancel in in YouTube, so I'm just hearing Bobs and T's fucking yapping and chatting and snagging like do. Oh shit, you were just absent? You did a hooky? You were like, haha, fake out. Well, in reality, what had happened was there was a live, but it got recorded over because there have been so many lives that when you guys went to actually go watch the live, it appeared that there was no live, when in reality, there was always a live, but it was not documented, so you didn't know it. That's the truth of the matter. You like how I read that too, huh? I knew what she was saying. Do. Okay, so number 3. Here we go, Mr. Turco. Why, in a September 6, 2023 email to the defense, did McClellan claim that the Purdue professor's identity was unknown and perhaps would never be known, when in fact, law enforcement had known the identity of the Purdue professor, I was going to say if not before that, since mid-August of 2023, if not before that. They always knew who he was. They never didn't know. And why did the defense only learn of the Purdue professor's identity after the Franks memo was filed, calling out the prosecution for absurdly claiming it may not be able to learn his identity? Me too, Sleuthy. I was just thinking as I was reading this, like, it's like an itemized list of Nick bullshit. Nick's bullshit. And it's like, okay, let's talk about all the times that this fucking guy lies. We may never know. We may never know. Yet every internet sleuth, as soon as they heard Purdue professor, figured out exactly who it was. But here's Nick and his investigators that are like, we don't know how we're ever going to figure this out. What do we do? Cecil must have been off that day, so they couldn't Google it. That's the only legitimate reason I can think of. There was nobody to Cecil it. Yeah, such a pattern. And T, my theory is the same as yours. They know who did it, but oh well. And total side comment here. Once again, just my own thought process, and I could absolutely change my mind. I've told you guys from the get-go, I had 2 POIs when I very first saw this case, and one of them was Tobe, and one of them was Brad Weber. Those were my very first 2. And then this might be the conspiracy part of my brain going, why is Tobe being fucking hidden now? Tobe, who was doing documentaries and talking to people and doing all these things, doesn't take the stand, is supposedly, according to Holman, the one who's in charge of the investigation because he's the sheriff of Carroll County, right? and he decided he was going to keep the case, even though Liggett was the lead detective on it. He's still the man in charge of the whole thing, and decides not to give it up to anybody. Where the fuck is he? Oh, Luna, you know what? That'd be a good person to listen to see exactly this back and forth of what the Purdue professor actually said. And it's like, that's not what he said. No, this is what he said. But why the hell are you hiding Tobe? It's because of the mustache. The stupid mustache on the very first photos. I've shown you guys those very first photos that they put out on the news. I think it was the 15th when we look back at the timeline. They put these photos out on the news that do not look like the photos they put out after. The person in them looks different. Like they smushed him, and they blurred him. Like it's a clearer photo from February 15th than it became. And yet they say, oh, we gave the video to Disney and we gave it to NASA and we did all of these things. He did. He changed his appearance. I don't know. That's why I said that's probably, I have nothing to go with on that. Just the fact that he was my first one, and then it's all of a sudden he just He's now like a fourth string player in the whole thing when he was like first string for a long time. You want me to show you the photos? All right, if I have them handy, I'll do it real quick. Because you guys know my Delphi folder doesn't always like to cooperate with me. It's got too much shit in it. BG here. Okay, so this is from the news. Like the very first news. Like right off the bat. That was like one of the first ones that they used. Oh, you know what? It's probably, you know what? I don't know if I ever finished that part of the Prezi. I still need to go back and do all the law enforcement. Now, let me find you the other one that doesn't look like the same photo. Is it this one? Let me see. The smushed one. Look how blurry that one is compared to that one. You call this vibrant, BG? Well, but look at the difference. You don't see like one like being taller, clearer. It looks almost thinner, and then you smush him, and his face is blurred out. Hold on, I think I have another one that's like, you can see like he's smushed. I don't know where it is though. I may not be able to access that one super easy. I think it's in a different file. Hi, Criminal Network. Yeah, it looks different. Like this one's like taller, skinny, and he looks, I mean, it looks like he has a mustache. I don't know. Did the news do this? I have no idea anymore. All I can tell you is that it doesn't make sense to me. First pick's definitely clearer. And it's almost like like around the 2019 change of sketch. You know, sketch is not a photograph. It's like we can't have BG actually look like the first sketch because we're claiming that we already figured out who that is, and that's not him, but we want to make it so BG is actually the guy who kills him, but we said in our statement that he was actually cleared and we already know who it is. Like, what kind of tomfoolery is that? This is before Indiana media learned about locking the aspect ratio of an image. So then they just kept putting it out and it made it squishy, squishy. I didn't show you the toe. I can, though. Oh, hey, Andrew. Thank you. Late to the show. Catch the replay. That's okay. We're still going. We still got more. We still got more. Okay. So here's our Turco, Professor Turco. Frank's assertedly claiming it may not learn his identity. And yet another example of what appears to be an attempt to conceal exculpatory evidence. McClelland has yet to explain to this court or anyone else why he sent an email to the defense on September 6th claiming that he and law enforcement did not yet know the identity of the Purdue professor, and more curiously, that they never learn of the Purdue professor's, they may never learn of the Purdue professor's identity. The Franks memo was filed on September 18th. Coincidentally, the very next day, lo and behold, Jerry Holman actually found and interviewed the missing Purdue professor, Jeffrey Turco. Only 13 days earlier, it was thought that his identity may never be known. According to McClelland, but after the Franks memo, where the missing professor was discussed, he was found almost immediately. Well, we actually find out that that's not necessarily the case. I hope they go into that because he'd already emailed him and said, hey, sorry, it took me a few weeks to get back to you, or whatever that was. Let there be no doubt the Purdue professor's report and even his October 19th, 2023 interview revealed the murderers may have left behind sticks in the form of runes consistent with the defense theory. This is called exculpatory evidence. So footnote. Okay. While Turco admitted in his report from 2017 that he could not confirm what the sticks represented, he also said, the argument that these markings constitute an inscription inspired by Norse runes or modern recreations thereof is quite plausible. These words from Turco were not buried deep in the report, but rather in the very first paragraph. It would not be surprising if Holman or McClelland would want the defense to not have access to the report, as that report supported the defense theory that Norse paganists left the sticks behind in the form of runes. In his September 19th, 2023 interview with Holman, Turco commented, I think the idea that somebody is trying to kind of replicate, early Germanic, runic script, that seems, I think, a given. Oh, now we're just quoting the shit out of it. Both the report and Turco's own words in his interview stray far from what Holman represented in his August 10th, 2023 deposition as to what the Purdue professor's words were. Holman claimed under oath that the Purdue professor had stated that the sticks were not Odinism or any type of cult worshiping or any type of a group that would have conducted the crime. Holman, simply put, misrepresented under oath the findings of the Purdue professor, who never said that the sticks were not representative of Odinism. Rather, the words the Purdue professor used was that the possibility was quite plausible and it was a given. Holman's misrepresentation under oath is very troubling, and he has never explained himself to this court or anyone else. The defense believes that evidence supports that McClelland did not want the defense to learn the name of the Purdue professor, and thus the September 6th, 2023 email that McClelland has yet to explain. But they don't bring up the fact that he actually had emailed him prior, or it said like, hey, sorry it took me so long to get back to you. All right, well, maybe they get to it. Turco's report and interview supported the defense theory that the Odinist Norse paganists were the murderers that left behind runes at the crime scene. After Holman's September 19th, 2023 interview of Turco, Holman prepared a report dated, because reports are normally dated, Mullen, September 22nd, 2023, in which Holman admitted that he had known of the likely identity of the Purdue professor since mid-August of 2023. If this is the case, again, why did McClelland not disclose this information to the defense instead of claiming to the defense on September 6th that the identity was unknown and may never be known? Again, McClelland has never answered that question to this court or anyone else. To the defense, it appears as yet another example of McClelland's attempts to conceal exculpatory evidence from the defense, much like the Reese Davis letters, and it is not normal. Okay, number 4. Why did McClelland fail to turn over the faked crime scene photo found on Holder's Facebook page, even to this day? And why did Trooper Roland Purdy twice swear under oath that the faked crime scene image was found on Brad Holder's Facebook page before the murders, only to then change his story on August 1st of 2024 at the hearing on third-party suspect evidence? That's a great question. Great question, Trooper Roland Purdy. Why did you change your story? Mullen, why did you change your story? Why does everybody fucking just change the story when they get caught lying? Ugh. As has been noted in the Franks memo and at various other times, the defense found among the massive amount of evidence a report from Trooper Ryan Winters detailing evidence that suspect Brad Holder had an image on his social media pages that depicted 2 girls mimicking the very crime scene that law enforcement found on February 14th of 2017. This image depicted 2 young girls lying on the forest floor with sticks and branches on them, with one of the young girls' arms posed almost identically to that of the Liberty German. This bizarre image had existed on Brad Holder's Facebook page before the murders, according to Trooper Roland Purdy. Why would Brad Holder, an early suspect, have such an eerily similar image on his Facebook page? Unfortunately, the prosecution failed to produce that exculpatory piece of evidence. The defense had to drive to Georgia to obtain that image from the very man, Ryan Boucher, who had located the image. Has anybody seen Ryan? I haven't seen Ryan since the Franks memo. I hope he's doing well. Hope people aren't bugging him. Who had located the image on Brad Holder's social media pages. Trooper Purdy, then under oath at his deposition in the fall of 2023, confirmed that the image was in fact on Brad Holder's Facebook page, but that he, Purdy, did not find the image compelling because it had been on Holder's Facebook page for a few years. Oh, how would he know it was on his Facebook page for a few years if he then later comes out and says he doesn't even know if it was actually on his Facebook page? On July 30th, 2024, Purdy once again confirmed under oath that this eerily similar faked crime image was found on Brad Holder's Facebook page. Then, very curiously, just 2 days later, Trooper Purdy recanted his two previous sworn statements, now claiming that he could not confirm that the image was on Brad Holder's Facebook page. Sometimes I do. So I just wish they didn't. Okay. But he wouldn't have been able to say it had been on his page for years if he didn't know that it was on his page for years. If he's saying he can't confirm that it was on his Facebook page. If you can't confirm it's on his Facebook page, then why did you say it had been on there for years? Why'd you think that? I just randomly made up the fact that it was on there for years? Additionally, Trooper Winters claimed in his deposition that the Indiana State Police could not locate the faked crime scene image that at one time was in the possession of the ISP post in Lafayette. To this day, the prosecution has failed to turn over said image. This is not normal. It is also not normal for a seasoned state trooper like Roland Purdy to retract two prior sworn statements during a hearing in which the mimicked crime scene image was a central piece of the defense's argument to allow third-party suspect evidence at trial. Well, no, he was told that he needed to make sure. He said that he couldn't confirm it himself because he didn't go on his Facebook page and see it himself. But then how did he know it was there for years? Okay. So, number 5. Video of Brad Holder and Westfall in a pagan ritual in Fort Wayne. So the defense was fortunate enough to locate among hundreds of thousands of documents a 2-page email from Greg Ferenczi to Tony Liggett dated December 12th of 2018, in which Ferenczi describes a strange video that Brad Holder took of a pagan ritual in Fort Wayne, Indiana. Footnote number 5, let's see. This video is discussed in the Franks memo on page 67. We've watched that video. In the video, Brad Holder was tape recording various people in a ceremony, periodically yelling out things such as "Hail Thor." At the very end of the video, Brad Holder tape recorded Patrick Westfall standing next to a tree and using his hand to seemingly mark something on the tree. Okay, so Patrick Westfall says that he was putting something in the tree, right? That's what he says. So, I mean, once again, do we trust Patrick Westfall? It's weird. Like some of the people that are like, we deem them trustworthy just because they tell us what we want them to tell us. You know what I mean? I think you guys are picking up what I'm putting down. Very Keegan Klinus-esque. Susan Hendricks. That's just so stupid to me. That's so dumb. That is one of the dumbest things ever. Like, let's just forget all the crazy shit that some of these people have done and what bad people they are, and then go, oh, yeah, we're going to totally believe what they say. But this guy who has no criminal history is thrown into solitary and confesses to World War III, that fucking guy's telling us the truth, and he really did it. What? I don't know. In the email, Ferenczi commented to Liggett about Patrick Westfall marking the tree with his hand. This is significant because of the F found marked on the tree in one of the victim's blood. Law enforcement had believed that the tree was marked possibly by someone practicing Norse paganism or Odinism. The defense did not get a copy of this exculpatory video. Rather, it had to ask the prosecution for that video. Eventually, that video was turned over to the defense. It is not normal for the defense to continually have to request the prosecution to turn over evidence of an exculpatory nature that the prosecution has in its possession. Normally, the prosecution turns over that evidence immediately without any need to request it. This was yet another example of the state of Indiana holding on to exculpatory evidence before being forced to turn it over. I have yet to see proof that the World War III claims are false. Fair enough. Fair enough. Maybe this is all going to start World War III. The Klingons. Kleinus. Get your bankies. Tobe had red, rosy cheeks, and I can't get past that now. It's the Kegus Kleinus. He's no soda pop or pony boy. Oh, God, we're so far off. All right, anyway, okay, let me see. Okay, so here is the conclusion and the request. What has happened throughout this case is not normal. Prosecutors not turning over exculpatory evidence to the defense is not normal. Prosecutors holding onto exculpatory evidence until being forced to provide it to the defense by complaints from the defense is not normal. The prosecutors claiming that they can't locate a key exculpatory witness's identity, a witness, mind you, that purportedly altered the way that the case was being investigated, is not normal. Well, it's so weird to me that this professor in his report back in 2017 says that it's plausible, or it's plausible. We'll go with that. I don't remember the exact word he used. And that therefore makes it so that the unified command decides to stop following up on Odinism based on this Purdue professor saying that it wasn't Odinism, when the report says that it is probable that it could be sometime. Maybe they're going with the whole it's not Odinism, it's Norse paganism, it's heathenry, you're not calling it the right thing, so we're going to go with semantics on you called it Odinism and that's not what it is. Because remember, Purdy had asked for the report and was told it wasn't necessary. I think Purdy was actually the one that Becky Patty told about Brad Holder, and he went to his boss and was like, hey, this tip, blah, blah, blah. And they're like, no. We already have the Purdue report and it shows us that it's not that. So we're not following that lead anymore. It's all done. Later, learning that the prosecutor had knowledge of the witness's identity in spite of an email sent to the defense claiming that he may never learn of the witness's identity is not normal. Well, no, because all you have to do is fucking Google him, like everybody else did. The prosecution having no explanation for not providing exculpatory evidence to the defense is not normal. Having no explanation why a report that attempted to explain why key evidence is forever lost was not dated is not normal. Having a seasoned law enforcement officer recant 2 prior sworn statements concerning a key piece of exculpatory evidence that the ISP claims it cannot locate is not normal. Finally, having a prosecutor claim in an email that he provided all the Reese Davis letters to the defense before trial, when just 14 days later he was forced to admit that what he, McClellan, represented as truth in his email was in fact not true. That is not normal. Nor is it normal that one of the letters can't even be located and the prosecution has no explanation for the missing Reese Davis letter. I bet Shank knows where it is. She'll find it one day. She'll find it one day. It does not matter whether the contents of those letters can be questioned as unreliable. That is not for the prosecutor to determine. The prosecutor's only determination is to determine that the evidence is to turn that evidence over to the defense. The defense should have had the opportunity to determine the value of that information contained in the letters. It does not matter whether those letters may conflict with other defense theories, as the defense has a constitutional right to possess all exculpatory evidence and then to determine how it should proceed strategically in the defense of their client. A local Carroll County rule also requires turning over said evidence. The fact is that the prosecution had in its possession letters in which a key suspect, Keegan Klein, purportedly confessed to the crimes and provided details that only the killer would know. And that information should have been provided to the defense. Because of the prosecution's failure to produce those letters, and because the prosecution has a history and a pattern of not turning over exculpatory evidence, Richard Allen deserves a new trial. Richard Allen, through his counsel, therefore seeks a hearing in which the prosecutor is requested to explain why he failed to turn over the Reese Davis letters, why he misrepresented his possession of those letters to the defense counsel in his February 13th, 2025 email, as well as to explain the other examples of failing to turn over exculpatory evidence as recited herein, which show a pattern of such conduct. The defense seeks such a hearing in order to, 1, use the state of Indiana's answers to these questions in a renewed motion for a new trial based upon newly discovered evidence, and also, 2, in order to use the state of Indiana's answers to those questions as a record that can be utilized by the appellate lawyers should this court deny Allen his request for a new trial. Lastly, Allen asked this court to order sanctions against the state of Indiana for violating the Carroll County local rule concerning exculpatory evidence. The sanction the defense is seeking is ordering a new trial. I swear and affirm that the statements contained in this memorandum are true and accurate to the best of my knowledge. There you go. It's not normal. I don't know how else it could be stated. I mean, it's such a perfectly said, it's just not normal. The way that they've gone about this entire thing is not normal. The fact that a judge doesn't give a shit that all of this has happened is not normal. The fact that we have a jury who convicted a person on a crime that we have no idea whether he actually committed it or not because they falsified so much of the fucking info or got rid of the info. Or here's the biggest question that if you want to know, if you want to think about what else does Nick fucking have? If he's done all of these things, which we know he has, if all of these things have happened and he keeps hiding shit and keeps hiding shit and keeps hiding shit, why doesn't anybody question what else fucking Nick has? You think she's even going to read that? No, Snappy, she's not going to read it. She may skim it. I don't know what she'll do. Maybe she'll read it. She won't give him a hearing. It won't matter. But this is, like he says in here, it's like we're putting all this down though because this is important. In other cases, once they've reached the appellate level, have been turned over based on the fact that the prosecutor has a pattern of not turning over exculpatory evidence. What does Nick have that they don't know to ask for because they're not supposed to have to ask, right? How much more shit is there? And this isn't it. He can't, there's no way that it's just like everything that he hid has gotten found out about. He's still got other shit. I bet little Nicky's doing his Kegels tonight. The crazy part of it is I don't even think he sweats it because he gets away with it. It's like a kid who goes and steals all the fucking cookies and the parent knows they're stealing all the cookies and they don't care. Isn't that Jerry Holman's example of you should beat your child if they take a cookie or something? It's so weird. It's not normal. Somebody needs to look in Kathy's drawers. I'm not doing it. but somebody needs to look in her drawers for sure. Who knows what's in those drawers? That's what she should write that on the order. Denied without a reading. I don't think you can call anybody. I just don't think I don't think you can call anybody because then who's he report to? The attorney generals, and that fucking guy is a douche too. He just doesn't want to be a part of anything scandalous. So he'll pretend there's nothing scandalous just because he doesn't want his name attached to it. I mean, shit. We, the public, still don't know why in the, the cover of Night, Richard Allen was taken from Westville to Wabash. Yes, that's true. You've got it. You've got to look in Kathy's boxes. You got to look in her box. You have to. You got to check her drawers. Somebody needs to. Yes, I nominate DB to go through Kathy's drawers. Absolutely. Let me see if my photo ever loaded so I can show you the other one. Oh, they're smushed. It's so smushed. I don't know. This might actually be. I'm going to zoom in because this is like a. No, maybe it's not this one. It might not be that one. Let me see. I don't know if I have it handy. I'd have to probably dig for it. Up. Fuck, I'm tired. Yeah, I don't know where it is. You got a shadow ban? All 70,000 tips have been in Kathy's drawers. Who blurred out his mustache? I don't know. It's so weird. He absolutely had a mustache. That's not it. I went back and I was listening to some of the older interviews with Becky. I swear, I feel like I have like a weird Mandela effect going on with this whole rose gold phone. So if you guys have gone back and listened and found where it's either her or Tara, and I don't know why that's in my head. That's what I think. Maybe it's a screenshot. I don't even know anymore. That's why I said I feel like I have a whole Mandela effect about the stupid rose gold phone. That I swear for years I've thought her phone was rose gold. Why do I think that? Has anybody gone back and figured that out? No, because I didn't talk to Julie till I never spoke to Julie until 2024, and I've always thought that. So I mean, Julie will say it's rose gold, but I didn't talk to her until last year. No, my memory says that it was an interview where she was talking about the phone, what kind of phone it was, the color of the phone. Like I have it in my memory, but I can't put anything with it. Like I can't. Maybe it was Kelsey. I have most of their interviews downloaded just in case, but maybe it was. I don't know. I guess I'd have to go back through and everything. A rose gold iPhone is listed in documents. iPhone 5S is rose gold. iPhone 6 Pro black, front silverback. I thought that the first year that the iPhone came out with rose gold was the iPhone 6. But maybe I'm misremembering that too. No, because I like for years I thought her phone was a rose gold iPhone 6. You feel like you heard Kelsey say that. But it's like, it's in my memory from like years ago. So it's like, I can't pinpoint where it's coming from. So if anybody does find that, if you guys are listening to anything, from back in the day, and you find that, let me know. There's a picture taken in the kitchen with the girls, and there are 2 iPhones, one rose gold, the other Libby's. They spent so many years repeating unseasonably warm in sweatshirts. We don't even remember anything else. Yeah, it's not surprising with all the info. All right, let me see. All right, so do you guys want to take a look at the list of exhibits that they put in, or are you guys good? The first rose gold iPhone was the 6S and came out in 2015. I thought the 6 was the first one that had rose gold as an option. I think 4 or 5 was my last iPhone. You're good? Okay. I think they just blocked off the confidential ones. Yeah, like I said, I mean, we've gone through All Lies's list, maybe not in its entirety, but in different times we were talking about different pieces of evidence back closer to after trial, when I think we were doing like the what did we learn. But yeah, I think we're good. If you guys want it, just let me know. It's also like in the chats, and I know that it's on Reddit if you guys want to go through it. But All Lies has it on Twitter from her original OG one. The iPhone 5S comes in gold, silver, or space gray, according to Apple's website. Okay, so that's good. I'll wrap it up then. We've been on 2.5 hours. I have built a really big family tree for Brian Koberger that I'm pretty confident that I know who some of these people they claimed in that when we read the transcript for Idaho 4. I think I'm pretty confident on who the peeps are. I'm not quite done yet, but I've been really putting, yeah, I think so. So I that's what I've been working on in my downtime. When do I plan on starting the Todd Mullis stuff? When should I start the Todd Mullis stuff? Not tomorrow, because I have an ortho appointment. And I have not read any new filings, DB. The last filing I read was a Karen Reed one on the Todd's response. Or Todd. God damn it, Miku. I started reading your comment. On Todd's response. See, that's when I know I'm done. I can't read anymore. But that was the last one I read. So I will do it, Thomas. Don't you tempt me. I absolutely believe that Todd is 100% innocent. So it'll be a good case. But the last filing I read was from the Commonwealth's response in the Karen Reed. That was the last document I read besides Delphi. So if there's a new document for Idaho, I have not read it. I think all the last ones we saw were all the ones that Ann Taylor had filed, I think on the 25th, 24th, 26th. And she had them all sealed. I think that's the last I know about Idaho. I've been stuck in this damn transcript. You guys want to? I'll just show you guys. This has been my life, is going through line by line and pulling out every piece of information that is going to be relevant to when we go over it. This has been my life in building a family tree. Double dog dare you. Yeah, I absolutely think that Todd Mullis is innocent. 100%. R&M Tuesday night, Lo-Fi live at 10. Okay, at 10, so 7 my time. I'm going to read the Idaho doc backwards and mirrored. Oh, shit. You're going to mix them all up? There's a brand new filing. It's fucking wild. Okay, well, shit. I'll pull that up so I can read it tonight. And hopefully, my goal is I wanted to have the Idaho stuff done by tomorrow. I just don't know if I can because both kids have to go to the ortho, or 2 of the 3 do. So I don't know how much time I'm going to have to do that. So Todd Mullis, I gotta make sure that first trial was really stupidly clipped. So it's really hard to get it all together. I might have to find out. I don't know. So maybe Thursday. Well, pencil me in for Thursday, Indiana girl. Pencil me in for Thursday. We'll start Todd Mullis if I can get my shit together. That's where I'm at. Okay. So hopefully I can figure the rest of I want to have the rest of the Idaho stuff done because I'm still missing a piece that just makes me go, yeah, 100% I'm right. And I wanted to have that done before I did the live. So pencil me in for my schedule this week. It might be kind of all willy-nilly. I don't know. I'll throw them out there randomly. I don't have a good schedule yet. And then, so let me see. So on that note, I'll show you guys the toe. There's your toe for you. Go enjoy the rest of your Tuesday. R&M says she's going live at 10 Eastern. So that'll be in about a half hour. And I will hopefully see you guys over there. Maybe I'll be able to chat while I get some of the Idaho stuff done. Other than that, thank you guys for hanging out. And as always, I know, I know that you have 1,000 other places that you could spend your time. And yet you choose to spend your time here with me and the toe. And I appreciate you for it. Go enjoy the rest of your night. And I'll hopefully see you guys mañana. Bye.
Do you dare to follow me down? Head into the unknown. Down the rabbit hole. Where it stops, no one knows. We're going down. We're going head into the unknown.